Assalamualaikum warahmatullahi wabarakatuh, and a very pleasant evening I bid to Mr. Jadi, our respected lecturer, and all my fellow friends. So today I would like to deliver my case note, and I've been given a case, which is the case of Abdul, Rashid, Abdul Majid, and Island Golf Properties in Berhad. The citation is 1989, Volume 3, MLJ, and page 376. So, first of all, I would like to give the facts of the case, which is the defendants own, manage, and operate a social golf club. There are few rules of the club pertaining to the proprietors of the club, membership qualification, and others. The plaintiff applied to become a member of the club by submitting the necessary application form and duly executed a declaration contained therein which stated inter alia that he accepted and agreed that the board of the defendants had sole responsibility for the club, including the policies, management, operation, right to amend, vary, add to, or formulate such rules and others. A preliminary issue under O33, Rule 2 of the Rules of the High Court was presented to the court, and the main issue here is whether the board was entitled to levy and collect fees known as development fees of the members, which is pursuant to its power under the rules, which is the Rule 33 of the club's rule provided inter alia that the board shall be the sole authority for the interpretation of the rules and the bylaws made thereunder, and that the decision of the board shall be final and binding on all members. There are basically three helps in this case. The first is there is no contract between plaintiff and the defendant, as the plaintiff application was just a preliminary step, and the contract was formed only when the plaintiff accepted the offer by making the payment of the entrance fee and the first subscription. The second help is the authority to levy fees must be clearly be given by the rules of the club, and there was no such authority under the rules. The third help is Rule 33 clearly made the board the sole authority for the interpretation of the rules, and as it perverted out the courts from their jurisdiction, the rule was contrary to public policy and therefore void. So I have two comments here, which is the first is the content of the rules, and any changes in the rules must be clearly be given to the members. So, the liability of a member is stated in Rule 5, and as a whole, Rule 5 is about nobody shall not, by his membership, be under financial liability except for certain payments due under or levied under these rules and bylaws of the company. So, I am with the view of Judge 189, which Rule 24 only gives authority to levy and determine entrance fees plus any other fees payable as stated in the rules, gives the authority to determine the amount if such fees can be levied. Rule 24 cannot be given construction that will allow the defendants to levy any fee they like. The authority to levy fees must clearly be given by the rules of the club. I'm referring to the case of Walker and Wakehurst Golf Club Limited, which is on 28 April 2011, the club changed categories of membership for the club such that women can no longer play in the Sunday women's competition, that this subjects the applicant to a detriment as a result of a complaint to the ADB in breach of Section 50 of the Anti-Discrimination Act in relation to victimization. So here, the changes in the rules does not be informed to the plaintiff. Okay, the second comment that I would like to make is the interpretation of law and law that contrary to public policy. So I refer to the case of Baker and Jones and others, and here I am with the view of Judge Linsky, which is the interpretation of the rules is a question of law which the courts will examine. Therefore, the provision in Baula rules which making the Central Council the sole interpreter of the rules and their decision cannot be challenged in all cases is totally contrary to public policy and thus void. This is basically same with the Rule 33 in the case of Abdul, Rashid, Abdul Majid and Island Golf Properties, which makes the board the sole authority for the interpretation of the rules is contrary to public policy. The next case that I refer to is Lee and Showman's Guild of Great Britain. In this case, if parties should seek by agreement to take the law out of the hands of the courts and into the hands of a private tribunal, without any recourse at all to the courts in case of error of law, then the agreement is to that extent contrary to public policy and therefore void. Lord Judge Denning had mentioned that the committee cannot extend their jurisdiction by giving a wrong interpretation to a contract, no matter how honest they may be. The scope of their jurisdiction is a matter for the courts and not for the parties, that alone forewarn them. The other case that I'm referred to is Bumanji Adeshirwadia and others as Secretary of State. Nothing is better settled than that. When parties have entered into a formal contract, that a contract must be construed according to its own terms and not be explained or interpreted by the antecedent communing led up to it. And the other case that I am referring to is in the case of Race Relation Board and Charter and others. In this case, as applied to join the club, he was proposed and seconded. When his application was considered by the committee, the chairman indicated in reply to a question that he regarded as colours as relevant to the consideration of his application for membership. As application was rejected on the chairman's casting vote, as complaining to the Race Relations Board, who issued a plaintiff against the club, alleging that they had acted unlawfully by virtue of Section 2 of the Race Relations Act 1968. The committee's chairman's decision is regarded as discrimination, and as we all know, discrimination is totally against the public policy. That's all from me. With that, I thank you.